It seems the same three justices have dissented in most of the cases I've reviewed lately. This time, Justice Sotomayor wrote the dissent and Justices Kagan and Jackson joined. Throughout our nation's history, Congress has authorized agency adjudicators to find violations of statutory obligations and award civil penalties to the government as an injured sovereign. The Constitution, this court said, does not require these civil penalty claims belonging to government to be tried before a jury in federal district court. Congress can instead assign to an agency the initial adjudication, subject to judicial review. The court has blessed that practice repeatedly, declaring it the settled judicial construction all along, indeed, from the beginning. Unsurprisingly, Congress has taken this court's word at face value. It has enacted more than 200 statutes authorizing dozens of agencies to impose civil penalties for violations of statutory obligation. Congress had no reason to anticipate the chaos today's majority would unleash after all these years. Keeping to the pattern, the dissent focuses on tradition rather than the law. Yes, Congress authorized agency to award civil penalties. And no, the Constitution doesn't require jury trials, but it does require that right to be preserved. That means it's the right of the accused to request a jury trial, and the government is to comply. The fact that the courts have blessed this doesn't mean it's constitutional. Besides, as the Constitution states, it is the supreme law of the land, not the courts. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. However, the dissent seemed to have missed the Supremacy Clause when it was taught in law school. Oh wait, it's unlikely that the justices actually studied the Constitution in law school. Today, for the very first time, this court holds that Congress violated the Constitution by authorizing a federal agency to adjudicate a statutory right that inheres in the government in its sovereign capacity, also known as a public right. According to the majority, the Constitution requires the government to seek civil penalties for federal securities fraud before a jury in federal court. The nature of the remedy is, in the majority's view, virtually dispositive. That is plainly wrong. This court has held without exception that Congress had broad latitude to create statutory obligations that entitle the government to civil penalties, and then to assign their enforcement outside the regular courts of law, where there are no juries. The dissent points out that the court has found that Congress screwed up, but that's nothing new. The dissent also claims that the government is the sovereign. It would be nice if they actually looked up the word in a legal dictionary. A sovereign is a chief ruler with supreme power. In the United States, the sovereignty resides in the body of the people. The dissent thinks the government has the power to grant itself a right by law because it's sovereign. Yet it's we the people who are sovereign, so only we have the power to delegate a right to government. The dissent made another legal error. Beyond the majority's legal errors, its ruling reveals a far more fundamental problem: the court's repeated failure to appreciate that its decision can threaten the separation of powers. Here, that threat comes from the court's mistaken conclusion that Congress cannot assign a certain public rights matter for initial adjudication to the executive because it must come only to the judiciary. The majority today upends long-standing precedent and the established practice of its co-equal partners in our tripartite system of government. Because the court fails to act as a neutral umpire when it rewrites established rules in the matter it does today, I respectfully dissent. It's the dissent that's mistaken, and it's their position that threatens not only the separation of power, but due process. See, it's the courts, not the executive branch, that is designed to deal with the controversies in law. And just how is the assignment of a fine a public right? Furthermore, it's the Constitution that protects a person's right to a trial by jury, not this court. In fact, it's because this court acted as a neutral umpire that it recognized Mr. Jarkis's right to a trial by jury. Chief Justice Roberts made this point in his opinion. A defendant facing a fraud suit has the right to be tried by a jury of his peers before a neutral adjudicator. Rather than recognize that right, the dissent would permit Congress to concentrate the roles of prosecutor, judge, and jury in the hands of the executive branch. That is the very opposite of the separation of powers that the Constitution demands. Jarkis and Patriot 28 are entitled to a jury trial in an Article III court. Thankfully, Chief Justice Roberts' opinion won the day.